Meeting of the Board of Adjustment for July 22nd, 2015. Would the clerk please call the roll?
Mr. Alahousas?
Here.
Mr. Boris?
Here.
Mr. Roboski?
Here.
Mr. Eisner?
Here.
And Chairman Elliott.
Here. Okay, normally we have the reading of the quasi-judicial procedures for the board, but I see nobody in the audience that is here to object. Seeing and hearing no objections, I presume the applicants are not going to object to their own variance, so let's just proceed informally then to item number 3, the approval of the minutes. Let's take them separately. May 27th. Any comments? Hearing none, do I hear a motion?
Motion to approve.
All in favor?
Aye.
Aye. Any opposed? Okay, that's approved unanimously. And then June 24th. Any comments on the minutes? Do I hear a motion?
So moved.
All in favor of approving the minutes?
Hold on, did you get a second?
Is there a second?
Oh,
Okay.
okay.
All in favor?
Aye.
Aye. Okay. All right, then let's move on to number 4. Heather, if you please.
Before they do testify, though, whoever is going to speak does still need to be sworn in.
Okay. Anybody going to testify? If you could stand up and accept the oath, please.
Go ahead and raise your right hand. Do you promise to tell the truth in the matters before the Board of Adjustment for the City of Tarpon Springs this evening?
I do.
All right, thank you.
Okay. Ms. Erwiler?
Thank you. The matter before you is application 1556. It's for 1713 Avoca Drive. The applicants are the Sullivans. The request is for a variance to reduce the rear yard setback by 8 feet to allow the construction of a roof over an existing outdoor kitchen, having a rear setback of 22 feet in lieu of the required 30 foot. This application is actually in an R100 zone, so 30 foot is the required rear setback. That being the case, the lot is approximately 11,424 square feet, and what is the request is for the 10 by 10 roof over the existing outdoor kitchen. The applicant has installed shrubberies along the rear property line. There's also a chain link fence there. Those shrubberies have grown significantly since they've installed them. They are 80 to 90% opacity, so you can't really see through to the adjacent lots. They do have a gate there, so I was able to go around and look at the adjacent lots. The rear lots that are adjacent to this property are vacant currently. They have some beautiful trees on them. That being said, at this particular point in time, there is no active applications on those lots. They are vacant and may remain that way for some time, may be developed in the near future. There's no way of knowing that. That being the case, the lot is developed with the structure that is legally a legal lot of record for the R100 district. The special characters associated with this request have not been self-created, nor are they the result of any action by the applicant. A matter of fact, the applicant originally did try to put in this when they put in the actual pool enclosure itself. They tried to put this roof over the kitchen. They had a contractor. They assumed that that contractor had gone to the city and secured all of the proper permits. That had not been done. Because of that, that was put in illegally. They then took that improvement out. So what is in there now is just basically the screen enclosure with their outdoor kitchen, the pool. It's all finished. It was done under the previous permit, but the roof over itself could not remain because it wasn't legally permitted. Okay, it was the only portion of their improvement back there that could not remain because of it was not legal for it to remain. That being the case, they have sought this, they removed it and have sought this variance for relief to allow for that. Had they known that they could not put in that roof over when they designed the original pool and pool enclosure, they might have been able to shift things around. That being the case, that was permitted and was built. Again, they didn't know that they had a permit. They didn't have a permit. They assumed that they did because they hired a contractor. And because of that, this is what the reasoning for the variance here. And they can speak a little bit more to that situations that having gone through that. Again, it's for the installation of the 10 by 10 roof over. Basically, the pool enclosure can go as close as 5 feet, the actual enclosure itself. It's just the roof over that would have to be 30 feet. In this case, pool enclosures are allowed within that 30-foot setback. They can go down as small as 5 foot on the rear and 8 foot on the side. In this case, they're meeting their side setback. It's just that rear setback that they need the relief from. So that being the case, granting this variance would not extend them special privileges. There are other people in the neighborhood that are enjoying screen enclosures and those type of improvements in their backyard. It's consistent with the surrounding area. It doesn't change the character of this neighborhood. It's an existing neighborhood, and it will have no impact on or create a nuisance for adjacent property owners. That the request does conform to the comprehensive plan and the LDC, and there were no comments received at all. I've received not even a phone call on the sign that's been posted out there, actually prior to the 15 days, because I want to get it out there before the holiday weekend. With that, staff is recommending approval of the request for an 8-foot variance to allow the construction of the roof over the existing outdoor kitchen, having the 22-foot rear setback in lieu of the 30-foot rear setback, as it meets the criteria of the Land Development Code. I can answer any questions you might have.
Thank you.
I have a question, Chair.
Mr. Kowalski.
Were there any sanctions against the company that didn't get the proper permits?
No, because the owners came in and decided to rectify that situation. So there was no active code enforcement case. They could then go after the contractor for the losses that they have suffered, but I don't believe that they have done that. But there is no sanctions against that contractor because they voluntarily removed that structure. They didn't go through any kind of code enforcement case where the city could build a case for that fact.
Do we know if they've done this in the past? Do we know if they've done this in the past with other projects, this same company?
I honestly do not know that. I've been here so little
That's
time.
fine.
I do not know if there's been other active cases that have had this issue, but this has been going on for some time.
Is there a way for the city to help protect other homeowners in the future against this particular corporation?
The Pinellas County Licensing Board is one option. They do take complaints on contractors and things like that throughout the county that do things of this nature. There's nothing really in place in the city other than code enforcement, and code enforcement still goes against the property owners, not the contractor. And then in addition to that, there's also a consumer dispute resolution process that's in place for Pinellas County that would handle disputes like this between consumers.
Thank you. Do you know how this was discovered?
It was actually the property owner that came in, and I believe they can speak a little bit more to that process.
I'll let them do
gone
that.
through that.
Do you know why our building department did not discover that?
I don't know. Originally, the permit that came in, there was no documentation. They just went out and started.
Okay.
And it was the owner that forced that permit thing. Realizing that there was no permit, they came in and they met with Anthony, and that's how they started their process to permit the screen enclosure and the other improvements. And that's when they discovered, they have this half-built roof that had to come down because it can't be there without a variance.
Right, but there was a permit for the rest of the project?
Correct, but it was like an after-the-fact permit for the rest of the project. They had already started construction when they came in to realize that there was no building permit, so they came in to permit what they could, discovered that error, removed it immediately,
Okay.
and then sought this avenue to remedy the situation that they have.
Okay, thank you.
Comments, questions?
I have one question, just to follow up what Chris says. Don't we have a professional license for contractors that we issue?
A business tax receipt is not exactly the same thing. I don't believe that there's any standards or control. It's just for the privilege of doing business within the city to have a business tax receipt, and there's nothing that would go into how they're really conducting their business.
They are required, contractors are required when they come into the permit process to prove that they are licensed through Pinellas County, but again, if it doesn't come in if they don't seek the permit, then that review can't occur. And again, this is in a rear yard, so the likelihood of somebody going down that street and catching it is unlikely, without a complaint, really.
I have one more question. So the city has no recourse when a contractor or anyone starts a project and he has no permit, and then in the middle of it, he gets or she gets a permit.
We have recourse, it's the code enforcement issue, but since the applicant was voluntarily coming in to seek that permit, they're remedying the situation, so trying to take them through the code enforcement process. When they're trying to remedy the situation, that's the remedy that they would get at code enforcement, is they have to get a permit. And whatever they don't get a permit for, they would have to remove.
I have an additional question.
Mr. Hrabowski.
Would that type of roof have required in-process inspection?
Yes, the permit itself would have gotten inspections. There would have been a preliminary and a final, because I believe they did do some work to the pool, and there are several set inspections that happen. So depending upon the sequencing, the roof would have gotten, because it would have been part of the larger permit as the improvements, would have gotten an inspection, yes.
Okay, thank you.
I have a question. Does this roof...
Can you speak in the mic?
I'm sorry. Does this roof attach to the house?
No, it attaches to the screen enclosure, and there's quite a span between the outdoor kitchen and the actual structure of the house.
There's a photo in it,
Towards the end.
in the back of your packet.
Gotcha.
There's a group of photos there that kind of shows that there's a space. There's a required 3-foot space between a house and the pool. And again, this is on the side by the pool, so they're meeting those setback requirements.
I have
Mr.
one more
Morris.
question, yes. On the findings of the city, it's an 8-foot section that they need, which brings us to 22 feet easement. On the plan here, they have 10 feet marked, whether it's just a note or it's what they need. Just to clarify it, is it a 10-footer or an 8-footer?
That 10-foot is that 10-foot there, if you're talking about this 10-foot that's there, that's denoting the size of the actual roof. It's gonna be 10 foot by 10 foot. That's what that 10-foot is there. The setback.
It's not the concrete.
The setback that they have here goes, it's really hard to see on mine.
To 21 feet according to the plan.
The 21 feet looks like it's to the actual screen enclosure.
Right, which means that's where the concrete or whatever base they have on it.
And the roof would be over that, but it goes to the inside track because they got the metal track, so it comes in. So the request is for 8 feet so that they can only go as close as 8 feet.
Yeah, but that's gonna be short. If they have 21 feet now and they're looking for a 22-foot easement with an 8-foot roof
Yeah, you're right.
over, there is a problem.
We'd have to look to the applicant to discuss that discrepancy here.
We could do an amendment tonight, I believe, right, to fix it.
Correct, yes.
That should not be an issue. You can increase it.
Any further questions from this side? All right, well, it's my turn then. We're supposed to disclose what we call ex parte contact, and I'd like to do that right now. That the applicants are longtime friends of mine, and they did contact me several months ago, right after I was appointed to this board, and I did go out to the property and look at it. Did not make any decisions about the variance. I just wanted to disclose on the record that I did go out to the property on 2 occasions and talk to Mr. and Mrs. Sullivan. Heather, if I could talk about the ordinance that allows an after-the-fact permit variance without tearing down the structure. You know, there's an ordinance that says you can get a variance after construction has been completed if you fulfill certain criteria. And there are, I think, 4 criteria, and one of them is that the construction had to be permitted initially, correct? And can you explain what happened and why the structure had to be torn down before they came up here?
All I can tell you is what the applicants has relayed to me, that they spoke with Anthony, who is the building official, and Anthony suggested to them that they remove the structure and seek the variance because he couldn't permit it. And that's just me getting hearsay from the applicant. So that's a better question because they have the full timeline to ask the applicant because they were part of that process. I'm coming into it
Sure.
without the benefit of Anthony being present. I can't really, counter what they're saying.
Maybe if Mr. Sullivan is able to address that, if you're ready for Mr. Sullivan to address the board. Okay, it's your turn, sir. Please state your name.
Richard Sullivan, my wife Kathy, 1713 Avoca Drive. Thank you for your time, folks. We have been longtime residents of Tarpon, been in the same house. We retired. We wanted to go ahead and spend the rest of our lives in Tarpon in that house and make it what we wanted for paradise. We put a pool in. We put a major deck in. On the deck, we hired an architect to make sure everything was proper. And I pulled the permit. Everything was fine. That was taken care of. Then we hired a contractor to go ahead and do the outdoor screen cage and enclosure over my kitchen. Hired the contractor. It was written in the contract that he would provide a permit. So once we signed the contract, I ordered the outdoor kitchen, and unfortunately that's the section that had to come back down. When I started on the kitchen, I took pictures, brought it to Anthony. I wanted to make sure I didn't need a permit. He assured me I didn't. And then I asked how the permit was coming on the cage. And he looked up the file and he goes, that was denied 3 months ago. And I said, it was denied. I said, that cage is already up. And he said, well, it has to come down. So we had a hard time with the contractor. He's a licensed builder. He's been in Tarpon, or not Tarpon, he's been in the area for 30 years. Anthony knew him very well, knew him personally, and didn't understand what happened. But we did get him to come back, take a section of the roof down, screen it. Now we're shooting for the variance. If we get it, then we'll have him come back and put the roof back up. So it's a little bit of a hardship. It's really not a super crisis. We're just, everything's out in the rain. But that's how that came up as far as Anthony. Anthony suggested that everything's got to come down, and then we'll start over again. And the city would like us to go ahead and pursue legal action with the state of Florida on licensing. But I would like to get everything taken care of before I stir the pot.
That's it. Any questions of Mr. Sullivan?
I have a question, yes. Since you hired an architect to design and then you eventually finish the pool and the deck and all that, the variance that they have here is 21 feet. I'm going back to that 8-foot problem. Didn't the architect pick up this? Or the contractor when they did the pool?
I'm sorry, I'm having a hard time hearing. The architect I hired was for the wooden deck. Thank you.
You're asking for 22 feet when you have 21 already.
It started with, in Anthony's office, he looked at this and he goes, you're 22, you're 8 foot in error. He goes,
Can you get closer?
8 feet needed to come down according to Anthony, and I didn't go out there and measure it myself. I think this is a revised plan, I'm guessing it is, that the contractor, the aluminum contractor did. But I think you are right as far as it is 9 feet.
Okay, so if I'm understanding you correctly, you're at this point right now amending your application to allow for a 9-foot variance instead of an 8-foot variance.
Yes, please.
Okay. Okay, we're all okay with that?
Yes, we're fine.
And just to clarify, it's for the covered roof only, correct?
Yes.
Do you need to have an overhead, sir? I'm sorry. Do you need to have an overhead for the roof?
I'm not sure I understand. The roof it's aluminum, and it's supported by the cage, the screen enclosure.
The reason I'm asking that, if the roof is, let's say, 9 feet that you're going to place, then you must have some kind of an overhead.
Yes, it was the structure to support the roof was already in place, and it still is.
Okay. You're not going to have any overhead. You probably need more than 9 feet if you're going to need overhead. That's the eave that goes down to the roof.
I'm not sure I understand.
Well, the roof of the structure, usually the roof goes over the structure, over the wall, about another foot. You think you're going to need that?
I think this is a cage structure, so it's going to be flush because
It's
it's
going
got
to
a
be flush,
screen.
even with the
Gonna
wall?
be- Yeah, it's gonna be
Okay.
inside that frame.
You can see the picture, Chris.
I did.
It's basically inside the frame. It doesn't go over that metal frame of the cage.
Okay.
So as long as the cage is in fact 21 feet from the property line, as is being represented here, he would have that flush with the inside bracket of the actual pool cage.
Okay.
Where there's an inch or inch and a half of the metal bar. At least that's the way it appears in
I have
in
a
the
question.
things.
Mr. Burris?
Does the installation of a gutter, just in case he has to put a gutter there, has any effect on these 21 feet or anything?
Gutters are allowed to go under the yard encroachment section, are allowed to protrude into the required
Okay.
setback. So yeah, he
Okay,
would be
that's
able to
fine.
put that in if he chooses to or needs to, without violating the variance.
Thank you.
Mr. Saul, we just want to make sure that you have everything you need. You already went through some hardships. Just want to make sure you got everything so you don't come back again.
Very good.
Any further questions, Mr. Eisner?
No, I don't.
Can I pursue that point I had before? Remember my comment about the reason why the encroachment had to come down was because it was not permitted in the beginning?
Correct, it was in violation.
And there was, but
What we-
the ordinance there's an ordinance that says that you don't need to remove the encroachment if it was done inadvertently with a permit. Do you know anything about that? Do you recall the?
No, I don't.
Okay.
That's the thing, the permit was denied, and the structure was already up.
Well, just for the board, I remember last month I suggested we talk about the Board of Adjustment procedures and substance, and I may want to raise this issue. In this particular case, that this encroachment had to be taken down before he could even apply. And the reason for it is justifiable, that the construction was completed without a permit. But it wasn't the applicant's fault that it was completed without a permit. So maybe we can ask the commissioners to tweak the ordinance to state that in some situations where it's not the fault of the applicant, that they can allow the structure to be up there pending the variance, if I'm making myself clear, and I'm probably not.
I understand exactly what you're saying. And I think that if there had not been a variance required, they would have been fine to leave it up and then go through the permitting process. But the way that the code is currently written, it does state actually in the variances that you may not grant a variance for an existing structure that is in violation of your codes. So that would be, I think that would be the section that you would probably need to change under the Board of Adjustment variance conditions.
I think what it says, Regina, is, I'm going from memory, that it can remain in place for the variance hearing unless it was constructed without a permit. There are some other conditions that the applicant met, and he could have left it up there for the last several months and not have to have his range exposed to the rain and the weather and so forth. But we'll talk about that at the appropriate time, I think. So any further comments?
I just have a question. On these pictures here, this is showing the roof structure in place before you took it down?
I'm not sure what pictures you do have.
Want to take a look at these pictures?
white
Go back to the
furniture.
podium there, Sally.
Your question again?
Okay. The question is, on these pictures, this roof looks like it's intact. Are these pictures prior to your removal?
Yes.
Okay. So the same product is going to be put back?
Yes. What they did was take down a couple of sections of the fixed roof, screen it in, then I applied for the variance, and that's where we're at. If I do get it, then I can put the panels back up.
So now, instead of what I'm looking at, you have just a screen over it?
It's
Yes.
just screen over the roof.
Okay.
Can I show you a picture?
I understand what this is. I just didn't know whether, because you had said this was taken down, and I'm looking at a picture that it's up. So that's
No,
why I
it's
was trying to
down.
clarify.
It's been taken down.
Mr. Burris?
I have a question. Since this permit was denied, when you went to get a permit actually, after the installation of the whole screen enclosure, you said it was denied the application? Was that the point that the application was denied after the whole enclosure was made? You said initially there was no application for the enclosure, correct?
There was one permit pulled for the roof and the screen enclosure, and that was turned down.
It was denied,
But
okay?
the
Then
building-
he went ahead and built it anyway?
No, the building was already up. They did not pull the permit from the get-go.
Okay, which means the rest of the structure didn't have a permit. Why they only took out this 8-9 foot section? They didn't take the whole structure down? Since the application was denied.
Subsequent to the denial, the applicant sought a permit. So the rest of everything is currently permitted as it's shown. They actually went through the process. The reason for the denial was the fact that it couldn't meet the setback. So as soon as they removed those panels, they made it, the permit, something that they could actually issue.
Thank you.
So then the rest of the structure was permitted.
Thank you.
Any further questions or comments? Words of wisdom? All right, we're ready for a motion.
Move to approve.
Second.
As amended, this is for a 9-foot variance. Okay. Is there a second?
Yes, a second.
Chris? All right. Let's call the roll, please. Ma'am?
Mr. Alahousas?
Yes.
Mr. Morris?
Yes.
Mr. Roboski?
Yes.
Mr. Eisner?
Yes.
Chairman Elliott?
Yes. Well, your variance has been granted. You're now legal.
Thank you, folks. Thanks for your time. I appreciate it.
All righty. Staff comments. Ms. Heather.
Staff does not really have any comments at
Keep
this
on.
time.
I'll take that one, thank you.
Okay.
Mr. Chairman,
Yes.
just to reiterate to the board, I did pass out the rules of procedure. Those are the ones that are currently in place. As far as we can tell, they're the most recent ones that are available either from the clerk's office or from my office. But they are getting revised, and hopefully those revisions will be before the commission this month. Or I'm sorry, I meant the next meeting, which is in August, because I think their meetings are finished for July.
Did you say they're going to be revised? What are the changes you're expecting to make?
I don't know. I have not seen the revisions, but they're revising every board's rules of procedure.
And we are also allowed to vote on and adopt our own rules of procedure, right?
Correct. They just have to be in conformity with whatever the commission provides.
We vote on these rules of procedure. These are our rules.
Yes and no. The commission can impose their own rules, and then you can adopt in addition to what they provide.
In the past, these rules were adopted by the
Correct.
Board of Adjustment, and the ones before that were adopted.
Correct. That's typically how it's done.
On the back, it says conflicts. The adoption of these rules shall not prevail over any ordinance, charter provision, court ruling, or state statute in conflict with the provisions hereof.
That's standard, but it doesn't mean the city commission.
It doesn't state that.
Well, we'll look at it and make our thoughts down.
And also with respect to the provision that you were just talking about, and it's contained in 215.02, subparagraph 5. It says that the city shall not accept an application for, and neither the board nor the city acting under this section has the authority to consider or grant variances that arise from a request for after-the-fact relief from the provisions of the code where the building or structure has been built in violation of the code and no building permit was issued for such construction except as provided in 215.02E. And that provision has the circumstances that say the property owner or contractor has made a mistake in the construction of a structure, and it would be economically impractical to correct the mistake at the time it was discovered. 2, the appropriate building permit or other use permit had been issued. 3, such mistake could not have been avoided by the application of normal construction or business practices. And 4, such cases proven by the board by competent substantial evidence. And looking at those, it doesn't appear that any of them would have helped in this particular situation, specifically because of the criteria that the contractor had to act in with respect to best business practices, and it doesn't appear that's what was done. But that would hopefully be a good revision to this ordinance so that in situations like this where it was not their fault and they tried to correct it as soon as possible, they would have some relief under the code without having to take it down like you suggested.
Could very well be that the builder is gone to Tierra del Fuego or somewhere and nobody around to tear it down, and it could be up there for a long time. Any further thoughts from the board? Mr. Boros.
If I can add one thought to this, it can also be collusion between the contractor and the owner.
Yeah, we have to get substantial competent evidence. I
Right.
believe these people.
No,
their
that's
fault.
fine, yes.
But
But
sometimes
also is
we
that
have-
possibility
We
there.
have to recognize that that could certainly happen, yes.
Thank you.
Anything else? We've lost 2 members, Mr. King and Mr. Haziak. We have our one alternate, who's now a member, I believe. Thank you very much, Mr. Heidner. So we're looking for 1 member and 1 alternate, or one. We're looking for 1 alternate, is that right? We've got 5 members now? The charter says we have 2 alternates, and the code says we have 1. And if you can recall, last year, we had a situation we couldn't get a quorum for like 6 months. We need to have as many alternates as we can, and we need qualified people. We got a wonderful board now, and thoughts?
Chris, are you still an alternate?
No,
So you're automatically, okay.
not automatic, it was voted.
Yeah, I think you were, it's just like 2 meetings ago.
Yeah, that's
they-
right, exactly.
They
Okay, so
appointed him.
we need 1 and 1.
We have 5. Mr. Eisner,
Right,
I
but
guess-
you were also speaking of getting 2 alternates.
Yes, yes.
So how do we go about making that change?
Well, any thoughts from the city attorney or city
The
planner?
charter provision would prevail over the ordinance provision. So if the charter provides that you have 2 alternates, that would be the basis for having 2 alternates appointed. And that can go before the commission as well to get the two additional individuals.
In the charter, it says very little about zoning, except that there shall be a board of adjustment, and it shall have 5 members and 2 alternates. So, the Charter Revision Commissions have always been adamant about that, and I think it's a good idea. And I've suggested 2 people to apply, 2 females, actually. They'll both look a whole lot better than we do, but one's a former city commissioner, and one is a local contractor, and they both agree to apply. And anybody else, feel free to contact members, prospective members of this board, and see if they're interested in applying.
There has been a public notification put up on the website that we're seeking alternates for this board as well.
Okay. Any further comments? All right, then let's adjourn. Meeting's adjourned. It's now 7:30. Good night. our next meeting is, we're going to have one, you think?
Right now, I don't have any applications, but your agenda is still open for another week. So it would be next Friday that it would be the deadline for the agendas, but at this point, I have not received anything.
Can you make sure that the city lets us know, because I might not be available in August?
Yeah,
So I'd
I'll
like
let you
to know.
guys know as soon as I know that the agenda's closed. If there's nothing, if we're not gonna have one, we'll cancel that meeting immediately,
By Friday,
next Friday.
by next Friday. Thank you.